Good afternoon and welcome to Little Steps Live. Today in Hong Kong, my name is Nikki and thank you for joining us. The breakdown of a relationship is always difficult, especially if there are children involved. Unfortunately, separations have become more challenging in Hong Kong due to its stringent COVID-19 measures. Some parents have had to immigrate and have taken their children with them, potentially without the other parent's consent, which could lead to the remaining parent to invoke the Hague Convention of International Child Abduction. Even if both parents are in Hong Kong and a divorce is amicable, there is still much to negotiate, such as ironing out proceedings relating to children, which involves custody, child support, visitation rights, discussing maintenance payments, division of property, and other assets. These are all very tricky subjects to discuss and often more difficult to agree on. However, with the right lawyer, you can get through it and hopefully arrive at a cordial arrangement that puts the welfare of your children first. And today we've invited a top lawyer to discuss what parents need to know about child protection and welfare during their separation. Now, before we get started with our topic, a few friendly reminders from Little Steps. We are live twice a month, and if you want to be reminded of our live sessions directly to your phone, make sure to check our Facebook events calendar and simply click the topics that you're interested in. Please also sign up for our weekly newsletters across all our cities in Asia, from Hong Kong to Singapore to Kuala Lumpur and beyond. The link for this is in the description below. Now we are live, so feel free to ask us any questions, add comments, and interact with us right here. If not, don't worry, we will get back to you after the live session has ended. Now I would like to introduce you to our guest today, Jocelyn Tsao, a partner at Withers Worldwide who has more than 15 years of experience in advising couples and unmarried partners on issues arising from divorce and separation, dealing with matters such as child custody, financial proceedings, and resolving disagreements through mediation, which are settlements outside of court and court litigation. She has handled complex divorce issues, including financial disputes with substantial onshore and offshore assets, and cases that have cross-jurisdictional and cross-border elements. And Jocelyn has joined us today to provide us with useful tips on handling everything from child custody to financial matters, so we can ensure our kids' welfare is a top priority. Jocelyn, welcome.
Hi, Nikki. Thank you so much for having me here.
It's a pleasure. Thank you for joining us. So, as usual, we'll be splitting up today's discussion in three main topics. The first one will be child custody and guardianship. The second is child welfare. And the third is financial issues. And at last, we'll have a Q&A, so feel free to ask us any questions, but you can't ask us questions during the live session, so just ask away. So here we go. Let's get started. Topic one, Jocelyn. Hi.
Hi.
Child custody and guardianship. How are you?
I'm good. Again, thank you for everyone who's here. I hope that this session would help educate people about some of the concepts relating to child dispute issues when it comes to divorce and separation. I think first and foremost, it's important for me to explain very basic concepts about child custody, because a lot of people we often say custody, we fight about custody, but actually I think a lot of people don't understand that there's actually custody being a legal concept and care and control being another concept. So it's important for me to clarify that. Now, custody legally actually means whether or not the parent could participate in the major decision making for a child. So things like where they should be educated, where they should live, whether or not they should have certain medical procedures, those sort of big decisions. So when people say, I want to have sole custody, they might not actually understand what that means, because that's not about the children staying with you. That's only in relation to decision making. Normally, generally, the courts will encourage parties to have joint custody, because unless there's certain circumstances which requires one party to execute decisions only, actually both parents should have the right to make decisions concerning their children. So The issue which people fight about the most in court is actually the second concept, which is care and control. Now, because the terminology control sounds a bit like setting out your territory. So it does, I accept that it does encourage people to fight about it and litigate it because they don't want to relinquish control over the children. In England, this concept is no longer here. They have like shared parental responsibilities in place. But in Hong Kong, we still have this concept, which unfortunately kind of provokes parties to dispute over it. Now, care and control means with whom the child lives with. It's as simple as that. A lot of people, I have so many cases where parties would go to court, go to trial on care and control, and they kind of forget that it's not really about the terminology. It's actually more about the sharing of time. So instead of saying, I want to have care and control because I don't want to give that up, and focusing on like my parental rights to have care and control over my children, I often encourage people to focus more on the sharing of time rather than being bogged down by the terminology. Yeah. So rather than negotiating from the standpoint of me having more time with the children because I deserve that because I'm a parent, you should try to like negotiate more on what's best for the children, and perhaps it's easier to convince the other parent to agree to you having care and control by saying that it's best for you to have care and control because of the different roles and responsibilities that you play as a parent. Between parents, there can be a lot of delegation of roles. Let's say the mother may be the one organizing the day-to-day activities, play dates, supervising the child's schoolwork, and perhaps the father may be like taking the children to their rugby practices, soccer practices in the weekends, that sort of thing. So each parent inevitably in all families would play a certain role and part. And I would encourage them to focus on maintaining the role that they play even when they're separated. So for instance, in the example that I just mentioned, if the mother is the one who organizes the day-to-day activities, tells the helper what food to prepare for the children, like take care of their school uniform, that sort of thing, then maybe it's best for the mother to have the weekdays with the children so she can ensure that their routines and their day-to-day living is well taken care of, while perhaps the father has more of the weekend time because that's what he's best at, perhaps. Like this is just an example. There's no gender stereotype. Yeah. But for instance, if that's the case, then maybe that's the way that should happen. And by acknowledging the other parent's role in the children's life, you're not saying, I want to have care and control of the children because I'm the better parent. You're saying, I want to have care and control of the children by them staying with me during the weekday, because that's I would like to continue those responsibilities and play that role, whereas I allow you to continue to play your role in the children's lives, which is maybe spending more time with them in the weekend or after work.
Now, and how do we handle custody? Let's say if we have joint or sole, how do we handle custody of a child or children and say they only want to spend time with one parent? How do we negotiate that then as parents?
So if there's a situation where you're saying there's a situation where a child wants to spend time with just one parent, right?
Exactly. Let's say you both have joint custody, but then the child decides, I prefer to actually spend time with just the mother or just the father.
So again, that I think it should be joint care and control, not joint custody, because custody refers to the decision making. So the day-to-day living, spending time relates to care and control. So if they have shared care and control, or if the care and control rests with one parent and the other parent has access to the child, but for some reason the child refuses to spend time with the parent who has access,
Mm-hmm.
then one needs to understand why that is, because it's quite abnormal for a child to not want to spend time with a parent. So you have to investigate, perhaps understand whether it's a result of perhaps manipulation or influence from the other parent, or if it's a genuine fear of the other parent. Usually, in most cases, it's actually the former. So usually it may be a result of certain things which the parent or the child may have said without the intention of causing alienation, but may have said something which makes the child feel like, okay, mommy wants me to stay with her and not go to daddy's. So I should say that I don't want to spend time with daddy, so I please mommy. So even though a child may say they don't want to spend time with the parent, it may not be genuinely the case. So how you go about understanding what the real cause is, usually, especially during a divorce case, would be assigning a child psychologist or a child expert to talk to the child in their like expert sort of way. There's special ways of speaking to the child so they don't feel like they're being put on the spot. So child psychologists may get involved to understand the real cause of the child's resistance towards seeing the other parent. So if it's a case where the other parent is indeed trying to influence the child or manipulate the child into not wanting to spend time with the other parent, then my usual advice is to the parent who's doing that to stop and be careful of what they're doing or saying in front of the child, because usually in those situations, especially during divorce cases, the parent who has a child in these kind of scenarios would probably fold their arms and even silently applaud the situation because yay, my kid doesn't want to spend time with the father, and that's not really helping the child, because yes, in this moment you feel like you're the winner, but ultimately long term it affects the child's personal development if they don't have a healthy relationship with the other parent. So it's important to always put your child's best interest at the forefront of your minds. And with that aim in mind, you should try to work with the psychologist or child therapist to try to ease the child into re-establishing a relationship with the father, maybe in gradual phases. I'm not a child expert, so I can't really give advice on precisely how to implement this, but there are ways which the child experts can advise people to do that. And sometimes when the child says, I don't want to go to dad's, because they think that they're pleasing you, you as the mother, let's say, you shouldn't be saying, oh, okay, you don't go to father's then. You should actually say, no, you should go. And because you're the parent, you tell them what's best for them, despite perhaps their superficial reluctance to go.
Yes, of course. Well, and this kind of brings me on to the next question, which you have already answered in your first bit. But what is the best way to negotiate shared care and control so that both parents are happy when a separation or divorce does happen?
So shared care and control, meaning both parents have more or less an equal time with the children, means splitting the week with between both parents. So in practical reality, it may mean 1 week with the father, 1 week with the mother, or splitting the week in half. So Monday to, let's say, Wednesday or Thursday with one parent and the rest with the other parents. There are a lot of ways to splitting care and control. The best way to negotiate and discuss with with the other parent about this would be mediation. I cannot say enough good words about mediation because it's the best way to discuss children affairs. When it comes to sharing of time, there's a lot of minutiae details which you need to discuss, such as like we call the handover and drop off time. There's the splitting. You need to look at the child's current daily routine and activities and see what kind of schedule works best for the child. And usually, if you leave it to the courts, it would just be like incurring a lot of legal time and money, and ultimately the judge don't know the details and what's best for your children. So it's best that you both work this out together. And the best way is through mediation, because there's a third party who's able to help you resolve your differences.
And just a quick, sorry to interrupt, just a quick question about mediation for those who don't know. Mediation is outside of court litigation. Do you both still have solicitors present? But there's no judge present. There's another solicitor, or are there 3 solicitors or 2?
No. Mediation is not litigation at all. It's just a means of trying to resolve issues between the two of you. And the beauty of mediation is because you don't necessarily, or I won't encourage people to involve lawyers, because then you save legal costs, first of all.
Of course.
And sometimes when lawyers are involved, inevitably maybe I'm a lawyer myself, but it may overcomplicate matters.
Yes, I understand.
So usually at the very beginning of mediation, and even during mediation, there won't be any lawyers involved. It's just both of you with the mediator. And you would first have an individual session with the mediator so that he or she understands what your concerns are, what your views are, before bringing you both into the joint session. Sometimes lawyers do get involved, and that's when, for instance, the mediator has already narrowed down certain issues, and there's just a few outstanding issues that they need to iron out. It may be some technical legal question that needs to be sorted in order to wrap the deal, and lawyers may then be involved to just assist on that.
I see. Okay, great. So mediation is a better way to go in order to negotiate custody or shared care control for parents, because it takes out the judge and the lawyers and all the extras that come with it. So it's just a more relaxed environment for both parties to come to an agreement to.
Yes. And once you achieve an agreement in mediation, then what the mediator will do is that he or she will draft an agreement up with all the agreed terms. And then you still need to transform it into a legal agreement. So then you pass it to your lawyers, you sign that legal agreement, you file that to court, and the whole litigation falls away.
Okay, perfect. And what if mediation, you do not come to an agreement in mediation? What is the next step? Is it then to court?
Yes, but even when we say court, there's a special kind of hearing that the court now has forces everyone to undertake, and that's called a Children's Dispute Resolution. We call a CDR hearing. That's not a trial hearing, so it's not what you see on TV where you need to be in the witness stand and being cross-examined and all that. It's a milder version of hearing where the judge actually acts almost like a mediator to give his or her view on the case and the issues of dispute. The intention is that by saying certain things, let's say the judge would say, "Oh, by looking at the case, the facts, I think perhaps mother, you should consider giving the father more time." Blah blah. So the judge may say certain things to encourage parties to rethink their positions and hopefully come to an agreement on the issues of dispute. The judge won't be making decisions, so the judge would at most be giving indications of what he or she thinks is best for the case. But ultimately, if you can't settle at the CDR hearing, then you go to trial. But you must try the CDR hearing first. And I have to say, a lot of cases do settle through this special, I call it a special hearing, where the whole objective of everyone concerned is just to help the parties settle.
I see. Okay, awesome. I think we have some questions coming in, but they're just coming in, so we're just gonna wait. So another question that I really wanted to ask: what if one parent wants to relocate to a country and the other one does not? Now you're through a separation, you're at the mediation, one wants to move, the other one does not. How do you get to an agreement with this? And how do you share care and control when you're both living so far away from one another?
Yeah, so if one parent wants to relocate to another country and the other parent does not agree to that, usually it's very difficult to settle this
Yes, I
through
bet.
mediation or even CDR because there's no middle ground. It's either you
No,
go with the
exactly.
children or you don't.
Yes.
Um, so usually, but there still is an opportunity to try to resolve things in mediation because sometimes when the parents say, I don't want you to relocate out of Hong Kong with the children, it may be because they are concerned about their time with the children being lost, or they may even be concerned with you not cooperating with facilitating their time with the children once you've relocated to somewhere else. And there are ways to reassure the other parent, for instance, by saying, okay, maybe you have more of the holiday time with the children instead of the usual equal sharing of holiday. I give you, let's say, 70% of the holiday. So
Mm.
you sort of compensate the time that you would have lost. Or it can be that once I've relocated to another country, to reassure you that I will cooperate with access and all the rest. I have no qualms with actually registering the order in that foreign jurisdictions. So
Mm.
so the other parent knows that you have the genuine intention to facilitate the relationship with the children. And for relocation, usually there cannot be shared care and control because ultimately the children will be spending the majority of time with the parent who relocates with them. So the other parent would only have access. So in cases where you've agreed on a shared care and control kind of
Yeah.
order, and then one party wants to relocate with the children, you would have to change the order for care and control so that the parent with who's
Oh, I
relocating
get
would
it.
have care and control. And that's very hard for the other parent to
Yeah, yeah, of
swallow.
course.
Yeah.
That's very interesting. Thank you. Another question that brings me on to this. So, especially nowadays with COVID measurements in Hong Kong and with Hong Kong still having quarantine. So, what if both parents are away for reasons like compulsory quarantine arrangement? I've heard something about a deed of guardianship is needed for the child. Can you tell us? Can you tell me a bit more about the deed of guardianship?
Yeah, so a deed of guardianship is a piece of document, a deed, which
Mm-hmm.
where you, as parents, appoint
Mm-hmm.
someone to have the physical custody of your children and also to represent their interests when you are not around. So traditionally, it's in the event of you being incapacitated or in the event of your death. But recently, because especially in Hong Kong, parents may be like for some reason may be forced to go to compulsory quarantine for a long
Mm-hmm.
period of time, or for some reason could not travel back to where the
Exactly.
children are because of travel restrictions. If you're worried that during that period of time there's no one who can help look after your child's affairs, then you may appoint someone to take over a guardianship for that limited time in the event that you're unable to be there for your children. So that person would deal with the children's like health, education, like the normal decisions that a parent would otherwise make, which
Uh-huh.
obviously involves signing certain documents if required. So let's say the school requires the parent to sign certain documents, or the hospital requires a parent to sign, but you're not here and you would like someone with authority to sign, then the guardian you appointed would have that authority. Um, so you would have to think about who's best to take on that role. Obviously,
Yeah.
you can have successor guardians where if that person, let's say you appointed your friend, but if that friend also for some reason is not available, then you have a successor, like someone else,
Mhm.
to take his or her place. But in before you actually sign the deed of guardianship, it's best to actually inform the person, because otherwise it would be a surprise when they
Yeah.
suddenly, yeah, when lawyer knocks and say, hey, can you, like, so and
Here's
so I pointed to you. Yeah.
I bet, yeah. But I imagine that it's usually the grandparents or a very close friend or
Yes.
something along those lines.
Yeah.
How about helpers? Can helpers be do helpers get deed of guardianship at
You
times?
you can, but I don't think it's advisable
Yeah,
because yeah, ultimately helpers are employed by you, and helpers
exactly.
can choose not to work for you.
Yeah,
Um,
yeah, of course.
it's just. I don't think it's reliable. And also, you want someone who's able to to assess whether or not they want to make those decisions for your children.
Very good.
Yes.
Yes. All right, fantastic. Well, that's closing our topic one of child custody and guardianship. For those who
There's
have
something,
yes,
sorry,
please
Nikki,
go on.
there's something I
No,
need
please.
to
Yes.
explain
Yes,
because
please
that's
do.
very important and relevant in the current times.
Yeah.
And that's circling back to the relocation, because I cannot tell you how many cases I have over the
Mm.
last 2 years, which involves Hague Convention, which is something you mentioned in the introduction.
Yes. The
Um,
abduction. Yes.
so in order for people to understand what Hague Convention of International Child Abduction is about,
Mhm.
um, I need to explain a bit. So
Please.
even if you have sole custody of your child, if you want to relocate with your children to somewhere else, or if you travel to some place and you decide to stay there for good,
Mhm.
you need the other parent's consent. Now, if you don't have the other parent's consent, what the other parent can do is to issue a Hague Convention proceedings, which is where if the countries are signatories to this convention, it basically means the central authorities of both countries would cooperate to facilitate returning the child to the child's habitual residence.
It
So,
feels all very so this happens quite often when I was first reading about it. It felt quite intense, and I can't imagine parents doing this to one another. But then I spoke to my friends, and they did tell me it's happening quite a bit, and
yeah.
on the rise as well. So I'm to be honest, I'm quite shocked. So it is happening quite a bit that the other parent will take the child without the other parent's consent.
Yeah, and I'll tell you why. Because of the pandemic, a lot of
Yes.
parents um, left Hong Kong with their children to their home country to, let's say, avoid COVID, or even avoid the really strict measures that's in
Or
place in
having their
Hong Kong.
children go back to school.
Yeah, so that when they leave, the other
Yeah.
parent may have consented, but
Okay.
the other parent has consented to it being a temporary thing for a few
Yes.
months, let's say.
I
And
see.
then the parent who has left actually finds, oh, I actually want to stay here. I don't want to come back to Hong Kong anymore.
Yeah.
And that's when the problem lies, because that's wrongful retention. So
I
even if
see.
it's not wrongful removal, it's still a wrongful retention, which falls under the Hague Convention for
And
child
how
abduction.
long is the wrongful retention? Because let's say the other parent agrees to a temporary move, considering how long it will be. When does that move into wrongful retention?
It's when, so you would have agreed on a time frame,
Yeah.
maybe certain months, or let's say most commonly before the child's next school semester or something like that.
Yes.
And when the other parent refuses to return after the agreed time frame, then the wrongful retention takes place.
Ah,
Or when
I
you
see.
say one parent say, "I want you back now in Hong Kong," and the other
Hmm.
parent refuses, then there's wrongful retention happening.
Ah, okay. I see. Okay. Thank you. Perfect. Would you like to move on to the next topic? Did you want to say anything else about child custody and guardianship?
I think that's pretty much it. I'll see if people have questions later
Yes.
on.
If people, I know this is quite a sensitive topic, so if people are feeling a little uneasy asking questions publicly on Facebook, you can email us at editor@littlesteps.com to ask your questions anonymously, and we will ask them to Jocelyn, and we will not mention your name. So if you do feel uncomfortable asking questions publicly, there's no problem in emailing us, and we will get back to you as soon as possible during or after the live session. So we're now moving on to the next topic. We are discussing what you need to know about child protection and welfare during a separation or divorce. We're now moving on to topic 2, which is financial issues, which is probably also a very big topic during separation, questions that are always asked between the two parties. And I'm going to ask so we've already touched upon this a little bit, but we've discussed whether a divorce needs to go through court, and whether it needs to be expensive. Now, we've discussed mediation. Are there any other options aside from court and mediation? Can you go, let's say if the two parties are not very financially, they don't have a lot of finances, so they potentially cannot afford to go through court. What are the other options?
So if they want to minimize the legal fees, mediation is the best way, as I said, because you just pay for one mediator, or you can settle, discuss and agree between yourselves. Usually, even if you settle outside court, I would advise that they seek legal advice at least when they actually prepare the agreement, embodying the terms of what they agreed on, because the legal agreement would have all the standard clauses that protects their respective interests and makes it full and final. So if they want to save on legal fees, settle outside of court, but find a lawyer to draft up the actual agreement. If the parties do not have any means to involve lawyers at all throughout the process, they can even represent themselves, which is actually what a lot of people do, but they don't realize that you can actually litigate in person.
Is that advisable?
If it's simple, then, and if you're confident, then maybe. But sometimes, like I've had clients come to me after they've tried to litigate in person for 2 years, and then they say, okay, I've created a mess of my case.
Exactly.
The judge was scolding me that I don't have my papers organized, etc. I really need to hire a lawyer now. So I have those cases as well, but I've also heard cases where people can litigate in person, and usually when the issues are more straightforward and the parties are not as acrimonious, then I would say perhaps it's possible to complete the whole divorce process yourself. You need to obviously dedicate some time, because there are documents online that you can download to know the template for filing these documents for pleadings, we call it. But if you don't have the time to do it, and you don't really understand what the whole process is, and you have no means to ask like your friends or whoever, or search online yourself, then it's best to have a lawyer, because it's just a lot more efficient. But I don't want to be encouraging people to necessarily engage lawyers, because if you're able to settle between yourselves, I think it's the best way if you want to avoid incurring a lot of legal costs. If there are a lot of financial issues involved, then yes, maybe a lawyer would help, because then you at least have advice on how best to protect your own interests.
I see. Which brings me on to my next question. What is the best way to sort out arrangement for maintenance payments? If you do have a lot of assets, or one has a bigger business than the other, or et cetera, do you think it is best to then hire a solicitor in order to iron out these maintenance payments?
If the issue is only on maintenance, because for financial disputes in divorce cases, there's usually two aspects. One would be the asset division, and the second would be the maintenance. In the US, they call it alimony. If the issue is only on maintenance, and actually that's a common scenario for a lot of young, financially independent couples, they don't have a lot of issues in terms of the capital division, but they do have issues on child maintenance, for instance. Then the best way to sort out those kind of issues is still going to be mediation, because what you basically do when you have maintenance disputes is you actually need to do a breakdown of your monthly expenditure, and that requires you looking into historical, like bank statements or credit card statements, or some guesswork of figuring out how much you've spent every month. And once you've had an idea of your historic expenses, your children's historical expenses, then you know actually what your needs are and what your children's needs are. And with that, plus the parties' respective income, you discuss what the appropriate contribution to the children's maintenance should be. One thing to bear in mind for maintenance is that maintenance is always variable. by nature, it's always variable.
Mm.
So let's say you agree on a certain amount now for the children, and they're just 2 years old, 3 years old. Inevitably, their expenses will increase as they grow older. So what you agree now may not be the forever sum. So that's why maintenance cannot be fixed for like indefinitely. So because maintenance is by nature variable, if the difference that you're arguing between yourselves is just, let's say, a few $100s or even $1,000, then I would question whether or not it's worthwhile to actually litigate over such meager sums, because the money that you put on legal costs in litigating this issue may overweigh the actual difference that you're arguing. So you need to have this balancing exercise. If parties cannot agree on the principle on how the maintenance should be sorted, then maybe, yes, I would say by all means, you might need to have the court adjudicate on this. But if it's just a bargaining of like a few $100 here and there, like for food, I don't agree that you should spend 1,000. I think it should just be 500. Like those kind of like sort of more petty arguments, I think it's best to resolve it through mediation. Instead of going to court.
We have some questions come in, which is great. So the first one is, can you explain the term nominal maintenance?
Nominal maintenance usually applies to spousal maintenance. Maintenance has two types. One is for the children, one is for the spouse. It must be separated. It cannot be a sum for both mother and children, because the duration is different. For children, it's until they finish full-time education. For spousal maintenance, usually the traditional duration is until death or remarriage, although now the courts are trending, like the movement is towards limiting spousal maintenance to a certain duration of time, but that's probably another topic. So nominal maintenance usually means just $1. Like it's a notional amount which provides an opening for the wife, let's assume, to apply for a variation of maintenance in the future. So it may be, let's say, currently your husband does not have income. Maybe he's unemployed, he lost his job. So because he has no income, it's really not fair to force him to pay you maintenance. But he has supported you throughout marriage, and therefore you should be entitled to maintenance. If that's the case, then you may want to go for nominal maintenance, which means currently, because you acknowledge that he doesn't have the income to pay, so he pays you just a notional $1, which is nothing. But when he does have a job, you would want him to support you, right? And he should be responsible to do that. So by that time, you can vary upwards the maintenance from the $1 to whatever appropriate sum that should be. So that's the reason why people do have nominal maintenance. So it opens up the possibility of you having maintenance in the future, a more substantive maintenance in the future.
I see. Another question coming in from a listener. Thank you. Please keep coming in. We're loving the questions. How about hiring a mediator versus hiring a lawyer for divorce? Is that doable, or what's the difference?
Mediator only facilitates the settlement negotiations, but mediator does, although some mediators are family lawyers themselves, family law practitioners, they because of their role as mediator, they are not there to advise you. So it's you can't say like mediator does not replace lawyers, because lawyers' role are to advise you on what your rights, entitlements are, and what the likely event would be if you were to go to court, so you understand what's reasonable, etc. So I think the ideal scenario would be that you consult a lawyer to understand your rights and what's reasonable, what's appropriate in your case, be it financial arrangements or child arrangements. And then you, with that in mind, with the understanding of what, let's say, your bottom line is, or what the range of how you're going to settle, you go into mediation. If you're able to settle at mediation and you still want to make sure if you are signing off on a deal which protects your interests or protects your child's interests, then at that stage, again, you can consult a lawyer to say, hey, this is what we have agreed, and we are about to sign this. Can you have a look and see if there's anything that I've missed, or am I signing myself to something which actually would cause troubles to me in the future? So you may want to have the lawyer again to advise you on what you've agreed on.
I see. Very interesting. Okay, good to know. Another question is, it says, how about rights of unmarried fathers over their children? Not.
Yeah, this is something which a lot of people actually don't understand in Hong Kong
Hmm.
specifically, is that
Okay.
unmarried fathers don't have rights per se, don't have parental rights per se.
Oh, really? I did not know about this.
Yes. And so that's why I have situations where, because people don't know about it, and when the mother, let's say it's the parents have not married, and the mother
Yeah.
decides to take the children or relocate the children to her home country without the unmarried father's consent. Actually, I dealt with a lot of cases where, because the father does not have the inherent parental rights per se, he can't invoke the Hague jurisdiction because
Oh,
he doesn't have the
wow.
rights. So
Okay.
if in that case, he can only apply to the local courts, i.e. in Hong Kong, to get a return order and then enforce it elsewhere, which is a lot more and cumbersome than
Yes.
going through the Hague proceedings. So yes, unmarried fathers don't have rights unless and until they apply to court to have, we call a Section 3 declaration. Actually, it's Section 3 of the Guardianship of Minors Ordinance. So it basically says that if you have Section 3 declaration, the court declares that you have the rights of a father as though your child is born under wedlock. So like normal fathers in marriages. So
And that is
until you
only,
have that, you actually have no rights.
I see. So let's say you're an expat family, you don't have permanent residency. Can you, but you have a child here, but you're unmarried. Can you still apply for this Section 3?
Yes, you can.
Okay.
So the test is you need to be habitually resident here, or you have
Mhm.
substantial connection here, you're domiciled here. So it's the same test as for divorces, if you want to issue
Okay.
for divorce in Hong Kong.
I see. Perfect. Good to know. So going back to financial issues, and I think we're going to keep getting questions in. People are getting warmed up now, so I'll interrupt every now and again. Um, to what if we feel if the maintenance that the other parent is suggesting is too low? I know we've touched on mediation. Do you think if there's no agreement, if you can't get to an agreement about maintenance pay and how much, do you then need to go to court?
Yeah, it might be so. Like if you can't settle outside of court, then the only option is to have the court adjudicate. But again, for financial matters, it's the same as
Mhm.
for children matters. There's going to
Mhm.
be what we call an FDR hearing, financial dispute
Mm.
resolution
Yes.
hearing, which is the special hearing that I just mentioned, where the
Yes.
judge would act almost like a mediator to help you settle. In order to justify why you're asking for a certain amount for maintenance, you'd have to have evidence to support your historical expenditure.
I
So
see.
I actually have clients giving me like piles of receipts for me to sort out what the historic expenditure in order to justify how much she or the family has been spending.
I see. We've got another question from one of our listeners. Thank you. How about rights of oh no, we've already got this one. Oh, sorry, she's repeating it. Sorry, she'll give me a new one. But there is this one. If a person is away from Hong Kong, can you still get a divorce, or do you need to be physically present?
So in order for you to apply for divorce in Hong Kong, either
Hmm.
one of you needs to, as I said, there's three requirements. You just need to satisfy one of them. So one
Okay.
is you're habitually resident in Hong Kong, so you've spent
Yeah.
at least 3 years living in Hong Kong. You have substantial connection with Hong Kong, so you may be working in Hong Kong, you have properties in Hong Kong, businesses in Hong Kong, your children are studying in Hong Kong, etc. Or
Mhm.
you're domiciled in Hong Kong. So you have if you don't have, obviously, if you're a permanent resident, then yes, that already establishes you're domiciled in Hong Kong, or if you actually have the intention to permanently stay in Hong Kong. So one of these three conditions, if you satisfies it, then you can apply for divorce in Hong Kong. And it's not both parties, it's just one party would be sufficient. If you're not in Hong Kong, the divorce process can still run as long as you have lawyers. You'd have to, in that event, you'd have to have lawyers here because you have to physically file documents to court, attend court hearings, etc. So it's best you have a lawyer here in Hong Kong to help you process the divorce.
I see. Another question from our guests. If you don't have access to bank statements or credit card information, how do you get this information if your ex-spouse is not providing this? Is this a common problem again?
Common problem would be the ex-spouse not providing the financial disclosure that he should give, which includes the bank statements, etc. So in the divorce process in court, there's the first and foremost thing that you need to do before you discuss financial issues would be to file and exchange a financial statement. We call it a Form E, the letter E. So the Form E would be a hefty document where you need to state what your bank accounts, disclose everything that you have, be it assets or income, etc. And you have to exhibit, let's say, 12 months of bank statements, credit card statements, etc. Now, that's the first round. Usually, more often than not, people don't give 100% of what they're supposed to be giving, unfortunately. So there's something called a questionnaire and answer, where you challenge the other side's disclosure to say, hey, you haven't provided me X, A, B, C, D, E, which you should have. So please provide it within X number of days. And the court will endorse it. So the court will actually order that your spouse provides or answers those questions. If your spouse still refuses to comply with this, then you may have to issue a specific discovery application, which is that you list out specifically what you want the court to order the other spouse to provide. And obviously, it would become a court order. And if someone breaches the court order, you can insert a penal notice. So if someone breaches the court order, then actually they're liable to be imprisoned because of breaching what the court ordered. But obviously you don't want to go that far, but that because there's the consequence, it's very unlikely that the party will still ignore the court order.
And with regards to this court order, let's say you're not in the same country. Let's say the person who's not providing you with the financial information is residing in another country. Can you still ask the court to?
Yeah, you can still ask the Hong Kong court to make those orders, and if the other person still refuses to comply, then you may need to actually hire lawyers in that jurisdiction where he is living to enforce the order. So I do have cases where there's where we have legal teams in different jurisdictions to get disclosure.
Of course. Interesting. Another question from a listener. What happens to your court order? That's if you've moved to a new country, if order is made in Hong Kong. So I guess that kind of.
Yeah, that's what I mentioned earlier, which is if you have a court order granted in Hong Kong, you, especially when there's ongoing obligations that a person has to comply with, then you might need to apply for a mirror order. We call it a mirror order. Actually, it's just registering the foreign order in that local jurisdiction. So you would have to consult a lawyer in that place where the party has moved to, and then try to get an order which is similar to what the Hong Kong order has made.
I see.
So we call it a mirror order. So it applies to both.
Perfect.
Yeah.
Okay. Fantastic. Now to we've kind of touched upon this already, but what if there are unforeseeable changes in your financial circumstances? How does that then change your maintenance payments? Would you have to go through mediation again, go through court again, or would you prefer to try to resolve this between the two of you, or how would you, yeah.
So usually they would try to discuss between themselves. Let's say if the payer uh, for some reason loses his or her job, or the income is reduced, he may want to reduce maintenance, and you may need to be sympathetic and understanding towards that and work out how the maintenance should be adjusted. Or if your children needs certain things because they're growing older, they're in high school or even university, and you need to increase the maintenance payments, then again, the payer, let's say the father, should understand that and try to resolve this and agree on an appropriate new sum for the child's maintenance. If you can't agree, then unfortunately, yes, you have to go to court. But one thing to bear in mind is when you do apply for variation of maintenance in court, inevitably the court will require you both to file financial disclosure. So that's the Form E that I just mentioned. Some people wouldn't want to do that, wouldn't want to go through the time and cost to complete a Form E again. So they might have second thoughts about whether or not they want to take it forward in court. But if the difference between both parties are huge. Let's say the husband at the time of the order has no income, so the maintenance is very low, but now he has secured a job back as a CEO of a company, and he still refuses to pay maintenance in principle, then yes, it's worthwhile to go to court, because the difference is too wide for you to be able to find a middle ground.
Fantastic. Thank you. We are now done with financial issues, the topic financial issues. Jocelyn, would you like to add anything more? Do you feel is everything been asked, or would you like to add any more to this particular topic before we move on to our last topic?
Yeah, I think that's pretty much covers what I want to say. Because the financial issues can be like, if you want to talk, we can talk forever. There's can be so many financial issues. So I try to focus it more on how it relates to children, which is children's maintenance. And I think that covers it. But again, if anyone has questions, then I'll answer them.
Yes, please feel free, audience, to ask any more questions. If you've just joined us, I'm here with Jocelyn, and we are discussing what you need to know about child protection and welfare during a divorce. She is a family lawyer from Withers Worldwide, and we're going on to topic 3, which is child welfare. Now, if you have any questions, feel free to ask us live on Facebook Live, and we are aware that the questions or the topic can be a bit sensitive. So if you wish to ask us questions anonymously, which have been coming in, and they're great, you can email us at editor@littlesteps.com. The email will be in the link in the description below. Feel free to keep asking those questions. So we're now in topic 3, which is child welfare. And how can we help children deal with the emotional upheaval of divorce and make sure that they are not at fault? I've been reading quite a bit, and I think the most common issue with children is that they feel that they are the cause or problem of the divorce.
Well, children may think that they are the cause or problem if you make them to be the reason for conflict. So first step, if you agree that inevitably you have to be separated or even get divorced, it's best that you both seek advice from a child expert, let's say a psychologist or a co-parenting counselor, to learn the ways to speak to your children or to announce the fact that you're going to be separated. It's important that you do that jointly, because you need to have a unified script on what to tell, what the message should be when it comes to telling the children that daddy and mommy are separating, but living in different households, and reassure them jointly that you both still love them, that they're not the reason why they're separating. Is just because there's ways of explaining why you have to separate, and the expert can tell you how best to say things, bearing in mind your children's ages, to
Yes.
not allow the children to think that they are the reason why you need to separate.
Okay. We've got another question from our listener. Are all divorces requiring a lot of money from lawyer, court procedures, etc., any winning party in a divorce case? And will the losing party need to pay for the winner's lawyer's fees?
That's a good question. So, how much money you need to pay in terms of legal costs will
Yeah.
really depend on how many issues there are. So, the more issues of dispute, the higher the legal costs.
Mm.
I cannot even give you a range of
Mhm.
what the legal costs may be, because it can be from $10,000 to millions of dollars.
Yeah.
Um, but as to the second question,
Hmm.
sorry, you mentioned there's a second
Yeah.
follow-up.
If the winning party in the divorce case
Yes,
will need to pay,
got it.
or will the loser party need to pay for the winner's lawyer's fees?
Yes. So usually for children matters,
Hmm.
because the court doesn't really want to penalize a parent for holding certain positions which he or she thinks is in their children's best interest. So
Hmm.
usually for children disputes,
Hmm.
there won't be a cost order. So you both bear your own legal costs, unless one parent is obviously trying to make things as difficult as possible. And because of his or her litigation conduct, the inevitably the legal cost escalates. And in those kind of extreme situations, and I've had those before, where I've had like 6 years of litigating on children issues because the father just absolutely will not agree on anything. So in those kind of situations, the court may order costs against the other parent
I
who
see.
refuses to be sensible.
I
But
see.
for financial issues,
Yes.
if you settle through the FGR with a
Hmm.
stage, which I just mentioned, where the court
Yeah.
helps you settle, there won't be cost orders because you settle voluntarily, like you agree to reach an agreement with your other spouse. But if you two were to go to trial on the financial issues, and the judge actually makes a decision or adjudicates on the decision, then yes, there may be a winning party or losing party. And
I
if
see.
it's straightforward, clear cut that one party's position was untenable and they shouldn't have held that position, and that's what caused them to have to go to trial, then the court will order costs against the other
Mhm.
parent. One way of protecting your costs, which most people do in divorce cases, would be while they're in divorce proceedings, they would issue an offer, a proposal to the other side to say,
Mm.
hey, look, this is what I propose to settle. And obviously, it has to be scrutinized by lawyers, and it has to be file proof, like file proof
Yeah.
meaning it's a position which the court is likely to agree with.
Hmm.
You issue that proposal, and if ultimately you go to trial and you win, as in the court agrees with your position, then the court will order costs against the other parent.
Okay. Okay. Very good to know. Thank you. We have another question. How to deal with the situation that one how to deal with the situation that one party does not follow the agreement to allow another party to visit their children.
Actually, that's a very extremely good question, because actually me and my team were just discussing about that.
Oh, great.
Um, in Hong Kong, it's the frustration is when there's an access order, say the father should be seeing the child at a certain frequency or whatever, and let's say the mother refuses to
Mhm.
facilitate. There's actually no strong repercussions towards that, because
Okay.
what you can do is to take the other person to court to say, hey, um, she breached the order because she didn't follow through the access entitlements that I have, and therefore um, she should be penalized. But how does the court penalize? The court won't put the mother in prison just because she's
No,
provisional
of
on
course not.
access. So what you can do is just to scare the mother into agreeing and cooperating with access. It's different from the UK, where there's actually some kind of like, if the mother refuses to facilitate with the court-ordered access, the court may order the mother to do certain like voluntary work, like cleaning the streets for a certain number of hours, those kind of things. But in Hong Kong, there's no such thing, which in my view may be one of the things that the legislation or the courts needs to address, because
I agree.
there's no strong consequences to a person not following through an access order.
And therefore, it will problems will arise, I imagine, and on an increasing stage.
And it's only when the one parent has failed to facilitate or cooperate with the order so much to the extent that you argue in court that actually, because if the children is with the mother, she absolutely will not facilitate my relationship with the children. That's why I want to reverse the care control. So the care control should now be with me, so that I would facilitate the children's relationship with the mother, and the children has relationships with both parents. So you may need to go to that draconian step where you actually reverse the care and control.
Of course. Another question from our audience: how do I choose the right lawyer that will meet my needs?
So I would always suggest that you have a first meeting with your the lawyer that you choose first, because it's very important for you to have a rapport with your lawyer. You need to feel comfortable, because ultimately divorce proceedings can be can be long, can be emotionally taxing, and you need to have someone who you actually trust and who you feel able to confide in and share things with. A lot of times I feel like my clients often rely on me, almost like rely on me emotionally. And that's very important, I think. Obviously, if there are specific issues that you anticipate happening in your divorce, let's say if you anticipate that your husband is going to be very difficult with financial disclosure, or if you have issues with specific issues with, let's say, your husband having a trust in an offshore jurisdiction, or if you have specific child issues that you anticipate will happen, then you may want to do some research to see which lawyer has more experience and expertise dealing with that.
I see. Thank you. Going back to child welfare during separation, how can parents best cope when they're worried about their child's welfare when they're in the custody or with the other parents? So I imagine that a lot of parents maybe feel uncomfortable with the idea that the first time that they're going to be separate, that the father or the mother has a long period with their child, and that has never happened before. So how do you best cope with these kind of worries, or what advice do you have?
Usually, in the court order or in the agreement on the access, usually if a parent has never been the parent carer and has very little experience in actually looking after the children on their own, then the normal agreement should be that it's a gradual increase of access, rather than all of a sudden the children staying, let's say, a whole week with their father without their mother, who they're attached to. So first of all, when you do discuss arrangements in relation to access, make sure that it's in a gradual phase, so you feel assured that the other parent has enough practice, so to speak, with looking after the children. Secondly, I would say most arrangements would include you having some kind of communication means with the children. So it may be that the children has your phone number or their iPad, so they can call you if they need. But again, I think it's important to bear in mind not to interfere too much while the other parent is having their time with the children. So don't always check in and bombard your children with messages to make them feel like you don't trust the other parent with them. But having that means of communication will make you feel more assured that if the children do have any concerns, they have a way to find you. So if they don't, then it probably means that they're actually okay. Or you can even ask them about how their day went with the other parent, but not in a way which interrogates them, makes them feel like you're grilling them, like, what did your father feed you today? Like those kind of questions. Maybe just ask them out of curiosity so that they would share. Yeah. Innocent inquiries.
Yes. Now, and that already brings me to my last question regarding child welfare during a divorce. And I think a lot of parents will question themselves. How can we best protect our children emotionally from any arguments that can arise during the separation? As you said, divorces can take long and can bring up a lot of emotions. Things can go quite bitter. So how do we best protect our children away from all of that? More the adult separation.
Yeah, it's very difficult, I would admit, for parents to put aside the animosity, the bitterness in the divorce to really focus on what's best for the children. But it has to be done. It's very difficult, and you need to keep reminding yourself. And
Yes.
by that, I mean you have to avoid putting your children in the middle, making them choose between parents, because that would absolutely destroy them. Avoid involving them in the divorce proceedings, so don't tell them what's happening. I have a case where the father actually showed the social welfare report to the children to say, hey, you said this to the social welfare officer, and starts grilling them about it. That's absolutely a big no. Don't show them any court papers or anything that because there would be papers being filed. There'll be things that you say on paper against the other party and vice versa. Don't show the children, obviously. Avoid also bad mouthing the other parent, because children nowadays are very sensitive and smart. They're also, especially if they're young, they're eager to please. So they will feel conflicted if they know you don't like something, but actually they want something. For instance, if they want to spend time with their father, but they know you don't like it, they would feel this sense of conflict and being torn between both sides. So avoid saying anything to denigrate the other parent. Ultimately, I think children nowadays can adjust to their parent separation, but what children can't deal with is conflict.
Yes.
The conflict between you two. It's not the separation itself, but the conflict. So just avoid showing to the children the conflict that you have with your parent.
Absolutely. Thank you. Thank you so much, Jocelyn, for today. Thank you for answering all our questions. Is there anything that you would like to add to child welfare during separation before we come to a close?
I think that's should pretty much, I hope, cover most of
too.
people's questions and concerns.
Yes, absolutely. I want to thank my audience for all your wonderful questions. As I said before, even though when the live session is ended, please ask us any more questions. We will get back to you. You can either ask us through email. All email addresses are down the link in the description. If you have any more questions about child protection, custody, divorce, or any kind of family issues, also please feel free to email Jocelyn at jocelyntsao@withersworldwide.com. Her email address will also be in the description. I want to thank everyone for joining us on Little Steps Live today. Many thanks to you, Jocelyn, and how to best handle child welfare during a divorce, and the breakdown was wonderful. If you'd like to see any more of our videos, please go to our YouTube channel or our Facebook channel. And thank you, everyone. Have a very good day
Thank you,
today.
Nikki, and
Thanks again,
Little
Jocelyn.
Steps for having me today.
Absolutely. Have a great day, everyone. Thank you. Goodbye.
Bye.